Hi, and welcome back to another episode of the To Me Mailbag. My name's Ben.
And I'm Andrea.
And this week we've got 5 questions that deal with disputes that arise in relation to property matters. The names are made up, but the problems are real. They're based on real situations that we see in practice all the time. And a quick legal disclaimer, nothing that we talk about in these videos is to be taken as legal advice. It's general in nature. If you've got a particular legal problem that you need to get legal advice on, then you need to see a qualified lawyer to take that advice. Don't rely upon things that we're saying. All right, let's get into the show. Some of the nastiest legal disputes don't involve big companies. They're between neighbours or property owners. Today on the Mailbag, we're answering 5 questions related to property disputes that people commonly ask us.
So the first property dispute question we have is that my partner and I bought a house about 6 months ago and we paid about $2.4 million for it. After starting renovations, we discovered significant water damage behind some walls. A contractor says the issue looks like it existed before the property was sold. Do buyers have any legal options when something like this happens?
Depends on the state as to what the options are. So we're just sort of talking generalities about things that are definitely relevant. What's super relevant here is that the contractor says the issue looked like it existed before the property was sold. The first thing that we're going to be looking for is what was done to potentially conceal this. So if the water damage was really obvious and nothing was done by the vendor to conceal it, and you got a pest and building inspector to go in there and they'd missed it, then your options might be to go at the pest and building inspector for negligence or breach of contract or whatever. They failed to pick it up. If they had picked it up, you would have not bought the property, or you would have actually successfully been able to negotiate a drop in the price or whatever it might be. The situation would potentially be different, although you still have a claim against the pest and building inspector maybe, if they had done something to conceal what had happened. So what we sometimes see is where the fraudulent concealment of this stuff takes place. It's less often water damage and more often termite damage. As you're smirking a little bit there, you're thinking of a few matters where that's happened. But things that a vendor might do, for example, to disguise a sagging beam that's collapsing because of termite damage, they might put cabinetry in a certain way, put some trim above it so that you can't see it or whatever it might be. If they've done that, then there may be a claim against the vendor. Depending rather on what other disclosures were made or weren't made. Obviously, there's different laws in different states about that. And there could also be a claim against the pest and building inspector. What you would need to allege against the pest and building inspector is that they failed in their duty to pick up the fact. So they were never going to pick up the water damage because it was concealed, but they failed to pick up the concealment. So we would argue and have that the pest and building inspector failed to see something and go, hey,
that's a concern.
That's sus.
Yeah.
That serves no purpose. What is that doing there? And then to say to the homeowner, like, look, that's sus.
Yeah.
There's no reason from a structural perspective why that would be there.
Yeah.
So I recommend that you do further investigations. And then the homeowner might say, well, yeah, we would have then asked for an explanation about it, or we would have asked for an invasive inspection. Then if the vendor denies you that right, then maybe you've got, subject to what your property lawyer, red flags galore, and subject to what your property lawyer tells you, you might have the ability to terminate or whatever it might be. So the other thing that you may look at, and I know that we deal with this later when dealing with statements by agents, you're going to want to look at what statements were made which potentially induced you to buy it.
Yeah.
And so if it's a property with water damage, but it's otherwise been beautifully renovated and it's been made to look like a palace, if the words that the agents have used in advertising it to you, assuming it had an agent involved, in advertising it to you, you also might have a claim against the agent.
Yeah.
Things like, everything's immaculate, but things like good as new.
Yeah.
Like those types of things where they're making the representation.
And what if the agent says renovator's delight, inferring that this is not quite right? The buyer is going to have to do some work.
Yeah, well, in those circumstances, and that's like, I think you're probably right there because they say after starting renovations. So obviously it wasn't a finished product if you're starting renovations. A
little bit of buyers beware.
Yeah, well, and the argument when talking about this sort of thing is, I was misled into buying this thing because you fraudulently concealed these issues. You're going to have to demonstrate that you actually acted on them and you would have acted differently had you been aware of it.
Yeah.
And it's often the case in a misrep claim that
Yeah.
you're not able to establish that you would have done anything different. It's like, yeah, look, you were misled, but you still would have bought it.
Yeah.
And you actually bought it for what it was worth. So there also sort of comes to consideration about measuring your loss. So sometimes, and it depends, we're not going to get into the different ways to measure loss, but sometimes the measurement of loss in a misrep claim is what's the position I would have been in had I not acted on the representation. And if it is that I wouldn't have bought it, then you're looking at the difference between what you paid for it in real simple terms, what you paid for it less what it's worth.
It's actually worth, yeah.
If you paid market for it, and even knowing the existence of the water damage, that's still market, you just wouldn't have bought it, then you've paid market for it. So other than your selling costs to flick it potentially, and sometimes you might not even get those, it might not be worth the powder and shot. Like you might have these legal options, but it's not worth anything. So
yeah, and I think obviously you've got to weigh up, you've got to mitigate your loss. So you've got this water damage issue, and you might think that the difference in value, as you said, is maybe like 100 grand, but it costs 20 grand to fix this issue. Are you better off going for the 20 grand fix and then trying to hit the previous owners up for that, or trying to offload it and claim the whole amount?
Yeah. Commerciality has to
prevail.
Be true. Yeah. I mean, because it's also can be the case with this type of damage, particularly termite damage. Like there's termite damage to such a degree that like the house is just hanging on, and it's like, hey, this needs to be knocked over.
Yeah.
Or for example, where there's like cracks in foundations, or where it's ultimately determined or found that like the foundations weren't laid properly and they don't go deep enough, or whatever it might be. Like there's some issues like this that actually are incredibly expensive to rectify. So what you're going to do about those could be the same fact scenario, but what you're doing about that is different to if it's just like, oh yeah, there's water damage that they didn't tell us about, but it's cosmetic and we'll just get it fixed. It sucks, but we'll just get it fixed, and we're renovating anyway. So always be commercial. Thanks very much for your question. Question number 2. Is developer next door causing cracks in relationships because of the noise, or cracks in their house? We'll find out. A developer started building townhouses next door to our house. Since excavation started, we've noticed cracks appearing in our internal walls and driveway. The builder says the cracks must have already been there. What should homeowners do in this situation?
Oh, I love this. The answer is so clear. Get a dilapidation report as soon as possible. In fact, before the development even starts, before they start digging foundations.
And this is critical if there's significant building work going on around your house, whether it's infrastructure work or it's a development going on next door. Yeah.
Maybe take photos.
Yeah. Get a dilapidation report. What's a dilapidation report?
It's a report that identifies the condition of the property. So what the idea is that you have a report that identifies the condition of the property before the development or the excavation or whatever started, and then you compare that with what the property is like afterwards or during. And if there is significant damage, then at least you have something in writing, or with photographic evidence, with an independent person's expert opinion, identifying that must have been cause of. Or not necessarily must have been the cause, but this is the evidence.
Just wasn't there, yeah. So the critical thing in, every case, evidence is key.
Yeah.
And you much prefer to be in a position where you can say, here is documentary evidence of the condition of the property. And a week later, you started doing your stuff, and this is the condition that it's in now.
Yeah. And let's say they missed the boat. They didn't get the dilapidation report early enough, but is there other evidence that the property was in a perfect condition?
Yeah.
This house that they're living in might have been brand new. It was signed off 2 weeks ago, reaching practical completion. There's no defects in that property that would have been, able to justify as a defect under that contract. So,
whereas if it was a house that was, 400
years old, it's 50 years old and it's falling apart already, then yes, the developer's going to probably have pretty good grounds to say, well, that was already there, and what evidence do you have to say otherwise?
So I think step 1 is getting the evidence. So if you've got the evidence of what's happened, you've then got to look at, okay, what right of action do I have against the developer? And that's looking at, or whoever might be causing it, what is the actual cause of it? So that's when you do actually have to connect the evidence to the cause. You see this sometimes with public works, where there might be like extensive, this is in the context of a development as well, the excavation can involve significant like piling or whatever that creates movement in the earth, and it creates structural issues and cracks. So being able to pin the result to the event that caused it
Yep.
is key.
Yep. I was going to say that if you were wanting to pursue the developer for a private nuisance, for example, and that is that someone's interfering with the use of your land and causing damage to your land by the way that they're using their land, you want to put that party on notice as early as possible, because until they've got notice of it, they can't be culpable to do anything about it. So the sooner you can say to the developer, hey, what you're doing here is causing damage to my property. Here's a report or here's a photograph. Cease and desist, essentially.
Yeah.
Or take whatever action you need to do to abate the nuisance. That's going to give you, best chance of avoiding the damage in the first place. But let's say down the track, they continue to do it and they do it for a prolonged period of time and it causes extensive damage, then you would have potentially a pretty good claim for private nuisance.
What we also see is the developers are cooperative.
Yep.
And they say, hey, we recognise that we're causing this damage. The best resolution is that, we're building this thing, let us fix the problem. So, which is potentially a really good position to be in for the homeowner. What you want to do there, though, is make sure that it's really clear the damage that they've caused and what they're doing to rectify it, and that is actually going to result in rectification, and then that you've actually got rights against them, rather, like you would if someone was doing any building work for you. You've got rights against them to go after them if the work's not rectified.
Let them in and
you see it often with people's pools crack and that sort of thing as a result of significant earthworks going on around them, or public infrastructure stuff where they're diverting sewers or whatever it might be. So, thanks very much for your question. It's a common issue. Do you want to read the next one? Tree damaging property.
Yes. So this is another common one, but the question is, my neighbour has a large gum tree on their boundary and the roots are cracking my driveway. The neighbour says it's a natural tree and not their responsibility. My neighbour's responsible for damage caused by trees.
I've got a question. What's a natural tree? Different to a fake tree, like a plastic Christmas tree? So it's not a plastic Christmas tree?
They infer what they mean is that the one that was not planted.
Oh, so it's already there. Okay, cool.
Maybe.
Cool. Natural tree neighbour. This is a good question. It's slotted in nicely because it's sort of similar situation to what we're dealing with the developer causing problems. I mean, if the tree is on the neighbour's land and the root systems are coming in and doing damage, we see this where it's cracking foundation. So here it's cracking the driveway, obviously. Also, what we commonly see is where it's interfering with pipes and lots of other stuff under the ground. It is a private nuisance thing. And the person who owns the tree, the natural tree, the earth owns it. The person who owns the tree is responsible for the damage caused by that nuisance and also abating it. So in certain instances, the tree needs to be gotten rid of. In other instances, there's other things. I'm not an arborist, so I don't know what has happened, but it can be abated. I think critically, if the neighbour saying it's a natural tree and it's not their responsibility, it's about, okay, you need to force them to take responsibility for it.
Yeah.
And you force them to take responsibility for it by putting them on notice of what you intend doing, just as you said with respect to the claim against the developer. And then if they don't do anything about it, then you go to court and either you probably wouldn't obtain an injunction. I'm just trying to think of the most effective remedy you would get. It would probably be you would get expert evidence about what you can do on your own land that abates the nuisance, and then you would cost that and seek to obtain a money order against them to rectify that. So if it was getting rid of root systems or whatever, and it was safe to do that from your property, subject to expert advice that's a way to do it. And then the cost of rectifying the damage that's being caused. So if you need a new driveway or you need a new slab or there's underpinning work or whatever needs to happen, the cost of actually getting that done. So you will be suing them for money rather than trying to get an order that they do a certain thing, because the court's only going to give those orders in certain circumstances. And if they don't do it, then you're back to court trying to get them to do it. So,
and if it's less serious, like there's a branch hanging over and it's, dropping leaves in the pool, or the branch is coming over and scratching the car as you're driving your driveway, there's state by state have got their own legislation to deal with like those kind of fence disputes or tree disputes, and there is something to be done there. So yeah, definitely looking that up.
Yeah, cool. Thanks very much for your question. The next question, agent misled buyer about development potential. A real estate agent told us a property we inspected could easily be subdivided. After settlement, the council told us the zoning rules actually prevent that type of development. Do buyers have any recourse if they relied on something the agent said?
Yeah. So there are 3 potential wrongdoers here. That is the agent. There's 3. The agent, the seller, the vendor, and the conveyancing solicitor who acted for you in the purchase. So this question is specifically about the agent. Going back a couple of episodes ago, we talked about the agent, being involved in making representations and that. I think the thing that you need to be aware of is that the agent is an agent of the vendor. So if the agent is making statements without the authority of the vendor, that is potentially making them personally culpable. If they are making statements about the potential subdivision without any basis to say that, without the homeowner telling them that's the case, then definitely be looking at a claim against the agent. If the vendor has told the agent, yes, this property can be subdivided,
here's a development approval that we got.
Please tell everyone that this can be subdivided. Then you can, potentially sheet that home to the owner. And then, but on top of that, you're sort of overlaying the fact that the buyer in buying this property has been legally represented during the transaction. So there's not only warranties in the contract to think about, there's other laws that have just recently been introduced about disclosure, and that might give you the right to terminate contract if you identify something like this prior to settlement. But you did or may have had an opportunity to get legal advice about the development prospects of this property. And if the lawyer, your conveyancer, has offered you to get a search to confirm whether you can subdivide or not, and you've refused, that could potentially mean that you don't have recourse against anyone. Because that would have been something you could do to mitigate your loss and potentially identify that prior to. If, for example, the lawyer, the conveyancer, did not advise you, hey, I have concerns that this property, what you've been told about this property being able to be subdivided is not true, I recommend you do this search, they fail to identify that, then that is potentially a professional negligence claim against the solicitor.
It all comes down to the context in which it's said, I think. So if it was the agent passing on information which the vendor has given them to pass on to prospective buyers, or it was in the marketing material, or if it was the agent just off-piste at the inspection one day, you can subdivide it easy. Then that's something. It probably also depends on the type of property it is. So like if it's a property, for example, like a large acreage holding or whatever, then maybe, as opposed to like a tiny piece of land in a dense area where it's obviously not going to be able to be subdivided, then
it's obvious.
The reasonableness of you relying upon it might come into it. And then proving, and this goes to what you said about the publicly available searches that can be done and the ones that you obviously pay for to verify any representations that have been made. Often the agent will get you to say that you've not relied upon any representations in entering into the contract.
That's pretty common.
Hold up. Yes, super common.
Pretty common special condition these days. But it's, like you said, is it a comment that's been made off the cuff, which, doesn't sort of appear that the agent has done any research about this, or is it something in the marketing material which is very specific?
It's subdividers paradise, or high development potential, whatever it might be. If they led the campaign with that, you're always going to come up against, as the buyer in these misrep claims, and they're pretty common, you're always going to come up against being put to proof on your reliance upon the representation. And it's always that you would have bought it anyway. We might have said it, and even if we did say it, it was wrong. It might have been wrong, or it wasn't wrong, or whatever. But none of that matters because you would have bought it anyway. And in any event, you paid market for it, so you've not suffered any loss as a result of it. So go.
And what would the loss be? Let's say there was a representation that was untrue and they've genuinely relied upon it, wouldn't have purchased it.
And it ends up being worth a whole lot less.
Yeah.
I mean, that's the cases that we've been involved in because that's the ones that are worth getting involved in and getting lawyers involved in. Depending on the circumstances, you potentially run a no transaction case. So it is, had I not been misled into buying this thing, and this is relevant to property or whatever, had I not been misled into buying this thing, I wouldn't have bought it and I would have kept my money. So using obvious example, I paid $2 million for it. It's actually worth 1.5. So I've paid $2 million for something based on representations that were made to me that were false and misleading. And I'm left with something that's only worth 1.5. So in order to put me back in the position I would have been in had I not relied upon the representation and not bought this thing, you need to give me $500,000 to get me back up to the 2.
Yeah.
That's probably what you'd be doing. Again, depends on the facts and circumstances of the case, but that's probably the most obvious angle that you would take here. So cool. Thanks for your question. Last question. I'm reading this one.
Yeah.
A retaining wall between my property and my neighbour's property collapsed after heavy rain. The rebuild cost is around $500,000. And we are arguing about who should pay. It's an expensive retaining wall. How is responsibility for something like a retaining wall usually determined? Andrea is laughing because the question actually says $25,000.
Yeah, $500,000 retaining wall is pretty neat.
They do happen though. So we've been involved.
I would hope that if you're spending $500,000 on a retaining wall, it does not collapse.
Yeah, you would certainly hope so. So I mean, I've certainly been involved in matters with a bit of involved retaining wall issues that have had retaining walls that are that expensive.
Yeah.
Usually it's where, you've got land and a heap of earthworks up on a massive slope and that sort of thing. So how's responsibility for something like this usually determined? It's actually, I've found it common in industrial developments where, they'll go in and they'll figure out how to make, how to get as many warehouses in this site as they possibly can. So, and potentially the maintenance in industrial developments is a bit more neglected than maintenance at homes. So, how do you?
I think we're missing a couple of facts here. Key information that we'd need to know would be whose property is the retaining wall protecting?
Yeah.
So whose land is being retained essentially, and then also is the retaining wall on the boundary? Or is it on one of the side's property as opposed to the other? And is there a fence on top of the retaining wall?
So when figuring out whose land it retains, you've got to go back to what did it look like before there were blocks there, before they were cut.
Yeah, we would just look at the original survey plan and get a surveyor to come out and mark where the boundary is. That's pretty critical because if it's entirely on the other person's land. And it's collapsed, and that's a nuisance issue, and it might be wholly their responsibility. If the retaining wall is on the boundary, that's totally different. That's potentially both of the parties' responsibility to then repair the retaining wall,
subject to who it's benefiting, and it's often the case that it's benefiting one in a certain percent and one in another. Yeah. I think what's also relevant here, and this is sort of what picking up your nuisance point. The retaining wall collapsed after heavy rain. Mm-hmm. Did it collapse because of the rain, or did it collapse because of how the rain was draining?
Yeah.
And it might be that because of the way the rain was draining from your neighbour's property, that's what actually caused it to collapse. Yeah. So let's just say that the retaining wall entirely favours it's on your lot. It's on your lot. It's not on your neighbour's lot. It doesn't retain their land at all. It's all yours. But the cause of the retaining wall losing its structural integrity and collapsing is because of the way that water is coming out of your neighbour's property. And that's a different type of action.
And if the party who has got the retaining wall on their property and they're on the higher property couldn't have done anything else to prevent it, and it's basically like an act of God which has caused this, it's such heavy rainfall that the retaining wall has collapsed, then...
And it's not because of anything that they've...
It's not because of it. They haven't exacerbated it. They haven't increased the risk, then...
They haven't put ag pipe to release right behind the retaining wall or anything like that.
All of that is relevant. So, I mean, if this was a particular issue, I would be getting engineers out to actually identify what the cause of the retaining wall collapse was, and looking at, how heavy was the rain? Is this a normal amount of rain that this retaining wall should be able to withstand all of that.
Some other thing. It could also be that the retaining wall was built poorly.
Yeah.
And then there may be a claim, depending on when it happened and all that, a claim against the entity that built the retaining wall. I think the critical point that you established there with any fight that involves this sort of a thing, and it's the same as with the question where the developer is causing damage, evidence of why something has happened is key. Like, what is the cause of the problem is key. That then can instruct, it can give you the ability to prove, well, you need it to be able to prove your claim, but when there's a number of different ways to approach a claim, you need to know why the thing has happened and what's caused the problem to be able to say, okay, this is what the problem has been caused by, or who the problem has been caused by. And so this is how we frame our action against that entity. You've also got to know if you've got different causes of action available against different people. You've got to then assess whether who you should be going after to give you the best chance of getting a recovery. Let's just say that there's a potential claim against the person who built the retaining wall and there's privity of contract between you and them and whatever. If they don't exist anymore, that's no good to you. Yeah. So you've got to then look at what other claims you can potentially make and who you can sheet home liability to. And what you're going to be doing there is trying to establish that it's something that the neighbour has done in relation to how water departs their property that has caused the issue.
Yeah.
Cool. That is a good one and very common as well. That brings us to the end of another episode of the Mailbag. Don't forget to like and subscribe, and any questions that you've got, please don't forget to drop them in the comments or send them to us by email and we'd be happy to answer them. Until then, we'll see you next time.